Welcome, everybody, and the second also seminar of this term. It's our great pleasure to welcome, well, in fact, welcome back Arushi Garg, who is now Assistant Professor of Criminology at the University of Cambridge and formerly a DPhil student here in the centre. Arushi is here to talk to us today on her work on rape and criminal justice in India, which was the subject of her DPhil and is currently being, I understand, turned into a book for Oxford University Press. So it's a great pleasure to have you back, and the floor is yours.
Thanks so much, Ian, and thanks everyone for attending. Thanks to Mary also for the original invitation, and it's a much postponed talk, but I'm really happy that I finally made it here. So as the title of my presentation suggests, I'm going to be talking to you today about women's legal worlds in Delhi straight trial courts. And my main focus is really going to be on this rather large gulf that exists between criminal law mythology on one hand and the actual practice of the criminal law on the other hand. And the fact that there is this gap between criminal law mythology and reality, I'm sure it doesn't come as a shock to anyone in this room, but it was a little bit of a surprise to me when I first started working on sexual violence prosecutions, the extent to which criminal justice seemed not central to the lives of rape complainants, including those complainants who had initially shown great energy and resilience in first getting the police to record and investigate the incident. So a lot of these victims also refused to support the prosecution during the trial. And this didn't intuitively make sense to me. So my paper today is one attempt at trying to make sense of this phenomenon. And I suggest that if we do want to understand women's experiences, women's uses of the law, their legal worlds, as Amrina Manji refers to it, then it's important for us to also look away from the criminal law and to ask the question of what is important to women. So hopefully that's a question I'll be able to give some meaningful responses to over the course of the next 45 minutes or so. So I'll start by introducing the broader book project from which this presentation draws. I'll then walk you through some conceptual tools that help me make sense of my primary data. I'll then discuss two categories of rape cases in which I argue that the outcomes are best understood by decentering the criminal law and by focusing on women's experiences and priorities, even when these conflict with what the criminal justice system assumes them to be. And I then end with some reflections on which interests are served or not served through the criminal justice system. So to start, this paper draws from a larger study about rape adjudication in India. And my interest in this topic stemmed from the discrepancy in conviction rates for rape cases vis-a-vis other categories of offenses, which is something that we see in many other legal systems also. So if you look at the latest figures from the Indian National Crime Records Bureau, for example, then the conviction rate in rape cases is about 27%, whereas the overall conviction rate rests at about 66%. And I don't want to, glamorize the idea of high conviction rates. And I also do accept that focusing on the legal category of rape also limits the projects in all sorts of ways. So in legal terms, for example, the crime of rape in India can only be committed by a cisgender man against a cisgender woman. But even with all these limitations, I think the discrepancies in conviction rates are so stark and they are so persistent that they do indicate that there is something distinctive happening in these cases. And so I was curious to learn more about what that something distinctive was. And so with this objective, I conducted about 6 months of fieldwork in Delhi's trial courts in 2016. And I gathered data from mainly 3 data sources, so including the total population of trial court judgments in rape cases in Delhi over a period of 12 months. I also conducted court observation in 6 courtrooms. And then I carried out semi-structured qualitative interviews with victims, victim support persons, various different types of lawyers, and also with judges. So a thematic analysis of this data yielded several factors that influence acquittal and conviction, but by far the most prominent factor influencing acquittals was that the victim refused to support the prosecution despite the initial complaint. So in juridical terms, they refer to this as the victim turning hostile to the prosecution. And in 151 of the 254 judgments I analyzed, this was the main factor associated with acquittal. So really, what's going on here? Why is it going on? Before I begin to address those questions, I want to say a little bit about my theoretical influences. So really the main theoretical backbone of the project is post-colonial feminism. Legal feminism in general has sought to identify, analyze, and also challenge the gender-based inequalities that are baked into the scope and operation of various criminal laws. Post-colonial feminist scholarship is particularly interested in how colonialism has shaped specific manifestations of patriarchy across much of the modern world. So that can include post-colonial societies, but also settler colonial or metropolitan contexts as well. And a really key feature of this analysis is the way in which in certain prominent strands of the anti-colonial nationalist struggle, traditional ideas of womanhood became enmeshed with national honor. And I'm going to say a little bit more about this process of the melding together of tradition and womanhood and nationalism, because I do think that this still exerts quite an important influence in India. So Partha Chatterjee and other historians have talked about how British colonialism in India, it involved the relinquishment of public political control by the so-called native population, which then, as a reaction to that, led to the entrenchment of networks of control that were exercised in the private sphere, right? So this meant that this had a heavy impact on gender relations more generally, but also very specifically on marital relations. And so in this nationalist imagination, Indian womanhood became symbolic of something pre-colonial, something that was untouched and unsullied by colonial contamination. And this type of elevated Indian womanhood was, by definition, most readily available to the elite women of the nationalist movement, who then happened to be relatively well-off, upper caste Hindu women. And once womanhood became symbolic of national honor in this way, of course, it became very important to then protect womanhood from corruption and colonialism and westernization. Women also had to be protected from their own sexual agency because, of course, a taint on women's respectability, even where it was self-inflicted, now became reflective of a stain on the national and communal honor. And what better way could you have of protecting women's respectability than the heterosexual marriage? So the centrality of the institution of marriage in Indian nationalist thought is really quite crucial to grasp. And given what was really at stake was the respectability of elite Hindu women, the version of marriage that was then emphasized by Hindu revivalist nationalists was marriage within the caste and within the religion, because this is what would then protect the so-called caste and religious purity of these women. So what all this bred was a system of controlling women's sexual autonomy, but with a view to then further reproducing caste and religious stratifications. And so under colonialism, pre-colonial entanglements between womanhood and marriage and gender and caste, they consolidated and merged together with questions of national honor in a way that has far, far outlasted the British Empire. And it's not that the story of this institution of marriage has been, has followed a neat or linear trajectory. So there have been quite important challenges to it also. But particularly in recent years, with the rise of a far-right hyper-nationalist government, there is once again a heightened focus on maintaining rigid ideas of marriage, which widen religious and caste-based cleavages. So we see this, for example, in the moral panic around so-called love jihad, which is basically when a Muslim man enters into a consensual romantic relationship with a Hindu woman. So within far-right ideology, this is then regarded as theft of the woman from the Hindu community, with a view to then destroying that community, because of course you need these women to be bearers of Hindu children. So post-colonial feminism then gives us a fruitful framework for understanding gender relations in colonial and post-colonial India. And it engages not just with the metropole and colony dichotomy, but also then with the system of other intersecting inequalities along lines of caste and gender and religion and so on. And this is useful for us because the decisions that women make in context of rape prosecutions can be quite heavily linked to the heterogeneity in their socioeconomic circumstances. And this is a point that I'll keep coming back to during the course of the presentation. Critics of post-colonial theory have suggested that it privileges European colonialism over other historical moments that can be equally or even more important. And it also doesn't have that the language of decolonization has now been appropriated by the authoritarian state. So you can have a situation now where the renaming of roads or picking islands and giving them Indian names can be regarded as a kind of decolonization by the government, even while young Muslim men continue to get lynched in public or on public trains or wherever on suspicion of carrying the wrong kind of meat, which offends these far-right sensibilities. So it is worth reminding ourselves that when we use this term coloniality, we are referring to a broader framework that includes multiple systems of oppression that are premised in the economic exploitation of others, and that exploitation is justified on the basis that these others are civilizationally or culturally backwards. So against this background, of course, British colonialism is an important historical force which casts its shadow over what happens in India today. But equally, it interacts with other contemporary developments, such as, for example, the rise of the far right in India today. And while the vocabulary of decolonization has indeed been co-opted by the authoritarian state, this is not shocking to me, right? Because this is not the first time in history that a progressive concept has been appropriated by an authoritarian state. I mean, we've seen this, for example, happening with the idea of feminism in many different contexts. So this is not the first time, and I would also be shocked if it's the last time. Just two more points to make in relation to post-colonial feminist theory. One, because post-colonial feminism understands gender as being mutually constitutive with other systems like caste and religion and several others. It is less vulnerable to the generalization that women are uniformly or homogeneously victimized. And again, this is quite useful for us because it creates the space to explore not just women's victimization, but also their agency. And again, this tussle between victimization and agency is something that plays out quite a lot in the rape cases that I'm going to be talking to you about today. And the final point to make here is that given the role that has been played across several centuries by colonial governments in creating, sustaining, and also entrenching gender-based inequalities, post-colonial feminist scholarship tends to be, if not critical, then at least ambiguous about the potential of the state to produce liberatory outcomes for women. And again, for our purposes, this is quite useful because this allows us to engage with women's legal worlds as they are, rather than as the criminal law system might imagine them to be. And this brings me also quite neatly then to legal pluralism. So legal pluralism, as the term might suggest to you already, it refers to the coexistence of multiple non-hierarchical normative orderings in society, of which state laws are only one form of normative ordering. That was quite a mouthful. I felt it as I said it. So to explain with an example, if I'm employed by a university, right? So my conduct might be regulated by laws that are imposed by the state. But equally, there might be organizational policies that my department or university impose on me, which also regulate my conduct. And apart from these sort of formal sources of regulation, I might also feel myself bound by informal norms or conventions about what it means to be a good colleague or what it means to be a good academic or a good teacher, right? And if I act in unconventional ways or if I violate these informal norms, it might not be the case that any formal disciplinary action can be taken against me, but I might choose to not do it anyway because I want to be accepted as a member of this broader academic community. And so in some cases, these informal norms or conventions might actually outweigh what the formal law wants or expects of me, right? So I think that legal pluralism is best understood by contrasting it with its converse ideology, which is legal centralism. So under a legal centralist framework, state laws exist as a single, unified, and non-hierarchical form of normative ordering. And again, there's lots that we could say about this characterization, but the point that I want to emphasize is the one about hierarchy. So under the legal centralist framework, the system of state laws would represent the most important and most dominant normative ordering, which would trump every other type of regulation whenever there is a kind of a conflict between the system of state laws on one hand and non-state community forms of social control on the other hand. So under the legal centralist framework, let's say a serious offense like rape is committed. The victim goes to the police because this is a serious offense. The police investigates, the prosecutor prosecutes, the judge tries the case, convicts and sentences the defendant. But under the legal pluralist understanding, that would suggest that, well, if a rape is committed, there might be many different responses to that, of which the criminal justice response is only one. It doesn't necessarily take priority. So if a rape is committed by one friend against the other, she might confront the offender might apologize, and that might be the end of the matter, right? So if a rape is committed by one colleague against another, the victim might request a line manager. She doesn't want to be in the same teaching team or the same work team as the offender. The line manager might arrange that, and this might be the end of the matter. In a different context, if a rape is committed, the victim might disclose this to her family. The family might force her to marry the offender. They might say that, well, this marriage now atones for the misconduct of the offender, and that resolves the case, and that's the end of the matter. Right? So we can have a variety of ways to responding to the incident, and whether the criminal law is relevant or not, and the extent to which it is relevant will often vary, right? So we can't assume that it will take priority over all other ways of responding to the dispute. Is legal pluralism a good thing or a bad thing? Again, there are many different responses to this. In the 1970s and 80s, to quote Mitra Sharafi, there was a spirit of aggressive optimism when it came to legal pluralism, because state laws were associated with imposition, with domination, with a flattening out of cultural differences. State laws were considered to be binary, adversarial. They generated winners and losers. Legal pluralism, in contrast, it seemed to offer avenues for dialogue and negotiation, right? It seemed to afford a greater recognition to cultural differences, which could often make it easy for parties to accept the outcome that was arrived at. But I feel there are also dangers to treating legal pluralism as normatively desirable in this way, because the main challenge for me is that community norms can also be sexist, casteist, and otherwise repressive. So my idea behind invoking legal pluralism is not to romanticize it or to put it on some kind of normative pedestal, But I'm using it in a descriptive rather than in a normative sense, right? So legal pluralism gives us a useful framework for understanding what is actually happening in trial courts. And as a matter of actual practice, sometimes the criminal law is peripheral to the lives of people. Other times it's significant, it's quite relevant, but it can be just one tool of many that people use to arrive at an outcome that they can live with. So using now my conceptual tools of post-colonial feminism and legal pluralism, I now want to turn back to the 151 judgments I mentioned, where the victim refused to testify in the prosecution's support, despite having initially complained about rape. 55 of these 151 cases were what is informally known in Delhi as promise to marry cases. And to me, they raise somewhat distinctive issues. So I want to park them to one side for now, and I'll come back to them in a bit. I want to focus for now on the remaining 96 judgments. So these judgments, they tended to recall quite briefly the victim's testimony that she wasn't supporting the prosecution because the initial complaint had only been filed because she had been pressured to do so, or because she had been misled into doing so by the police or by members of her family or by other third parties, right? But this quite cryptic summary of her reasons, to me, it really didn't fully capture women's motivations or reasons in these cases, as I gleaned them to be through interviews and through ethnographic observation. A more nuanced understanding of these motivations is available to us by examining the legal pluralist context, and also by analyzing women's relative positions of power and powerlessness within the post-colonial society they inhabit. So broadly speaking, the primary data revealed two types of cases, one in which the victim did feel pressured or forced to turn hostile to the prosecution on account of some direct threats or intimidation that was being directed against her. But there seemed to be a second type of case in which the victim's refusal to support the prosecution resulted from her having entered into some kind of an informal, voluntary settlement agreement with the defendant, in which the victim would undertake not to testify against the defendant during the trial in exchange for some other benefit or relief that was offered to him outside the space of the trial. And this relief could take on many forms, right? So it could be in the form of the payment of a monetary sum. It could be an undertaking that the defendant would repay a debt that he owed to the victim. It could be an undertaking to provide her with some kind of employment or to not fire her. It could be this understanding that he won't evict her from the premises she was occupying. It could be a promise that he would stop encroaching on her immovable property. There could be circumstances in which the victim was married to a member of the defendant's family, and in such circumstances, he could also offer her then a hassle-free divorce, including strong alimony rights and custody rights over her children. So the exact shape and form of this relief, it could be quite varied. It could be quite a multidimensional thing. But this also seemed to be happening in several cases. And while I've just given you this tool for classification, I'm going to withdraw from it partially almost immediately, because I do think that these weren't very watertight compartments. So the victim's willingness to enter into a settlement agreement, for example, was much enhanced if she was also facing some kind of pressure from the defendant, or sometimes even from members of her own family, because they didn't want to be associated with the stigma and the hassle of a rape prosecution. And the pressure on the victim, it could be relational or interpersonal in the way that I've just described, but it could also be institutional or structural, right? So when I talk about institutional pressures here, I'm talking about the fact that many victims, as they navigate through the criminal justice system, are facing a huge amount of re-traumatization. And this kind of secondary victimization can actually make it seem counterproductive to stick with the prosecution. It can make more sense in those cases to just like quickly and informally resolve the dispute and to actually get something out of the process, right? And not just sort of interminable delays or hostile treatment or whatever else they're facing. The pressure exerted on the victim can also be structural, and here I'm talking about the structural oppression of poverty, of homelessness, of debt, of being a single parent. And so we then have a situation where the victim is often choosing to enter into these agreements, but this choice is being made in a highly constrained context, where the victim is often having to choose the lesser of two evils, which can involve the creation or which can involve allowing impunity in the rape case. And so to give you a quick sense of the sorts of things that came up in the interviews, so this is a victim support person, and I specifically asked her about why victims might not support the prosecution, despite initially filing the complaint. And she starts actually by talking about some institutional pressures on the victim's family. So sometimes it is very difficult for the family to keep going to the police station and to keep going to the court. But then she recognizes that there might be other relational forms of pressure that arise because the victim's parents or her own family don't support the prosecution. And finally, towards the end, she talks about the structural pressures that can be imposed on the victim as a result of poverty. So she says, where the victim's financial condition is not good and they can't fulfill their needs, they might get distracted from the case and enter into a settlement with the defendant. Similarly, the next quote is from a highly experienced criminal lawyer. And she's talking here about women who face structural pressures by virtue of belonging to an oppressed class or religious background. And though she starts by talking about rape victims in communal rights situations, she then later in the video talks about how these are not issues that are specific to communal rights situations necessarily. So she says, nobody will care for her, the rape victim, and it is beyond a shadow of doubt that she will be approached, she will be coerced, she will be threatened, she will be made to somehow retract from her original story. Now she is poor, she cannot dislocate to another place, she is dependent on the male relatives who surround her, who are quite happy being paid off for her silence. At some point, she will just give up and say, okay, never mind, I am not proceeding further. And I could keep multiplying the examples, right? But these are, intended to just be illustrative quotes that bring out that there can be significant constraints on the victim's freedom to decide which way she wants to testify in a rape trial. And in several of these situations, the victim might arrive through a process of negotiation at an outcome that better serves her needs than the criminal justice system does. And so the trial is not directly serving the victim's needs in the way that is intended by the law, but the threat of a conviction can provide the background against which the victim is entering into this sort of bargaining process with the defendant to secure the least undesirable option in what is already quite an unhappy situation. It is worth noting that the withdrawal of the victim's support to the prosecution is routine and is usually not a reflection on the authenticity of the allegations or not. So it would not be correct to infer from the victim's withdrawal of support to the prosecution that the incident didn't actually happen. And the other point I wanted to emphasize is that when I say the victim enters into an informal agreement with the defendant, I do mean that these are informal in the sense that they are entirely extralegal and they are not enforceable in a more legal sense. Once a trial has commenced in a rape case in India, there's actually no legal way to just take it back in a straightforward sense. We do have plea bargaining and other sorts of legal mechanisms, but they're usually not available in a rape case. So these understandings between the victim and defendant, if you want to call them that, they are entirely extralegal, and both parties are actually at the mercy of extralegal societal norms that dictate that they must comply with the bargain that's struck. And so I want to end this part of the seminar by just reading out this vignette from my fieldwork, because I think it ties together some of the themes we've been talking about over the past few slides, and it gives a kind of behind the scenes view of what was happening in some of these cases. So please pay attention. That says, if you are not ready. So when the victim witness turned hostile, the judge got angry and asked how many years she should spend in jail for filing a false complaint. The victim witness seemed to panic and said that the incident had indeed happened, but she felt too ashamed to relate it in front of the men present in the room. The judge reminded her that they had already ensured that the testimony was recorded without the public present in the courtroom, and the only person she really needed to address was the prosecutor, who was also a woman. The recording of the testimony then proceeded, including the account of the rape. But once the matter was adjourned, the victim witness approached the prosecutor privately. She admitted that she did not want to proceed with the case because she had entered into a settlement with the defendant. The judge overheard her and was immediately incensed. He asked if she thought that the criminal justice system was a personal car that she could just start and stop at will. He warned her that he was going to make sure that the case was prosecuted till the very end, because she might have arrived at a decision, but the court's decision remained to be made. The victim witness protested, saying that she needed the settlement money to raise her children, but the judge was adamant, asking why she couldn't afford to raise her children when she was a working woman. The victim witness responded, saying that she had no stable source of income, she was a daily wage earner, and there was no guarantee of whether she would secure employment on any given day. After the judge left, the victim witness returned to the prosecutor and repeated that she wanted to take the case back. The prosecutor initially gave evasive replies, saying that only the judge could help her, but finally she told the victim witness to address her queries to the defense counsel. The victim witness added that she was under huge pressure from her landlord to take back the case, but the prosecutor did not react. After the victim witness left, the prosecutor was asked what would happen in this case. She said that there would probably be an acquittal, but none of the background conversations regarding the settlement would form part of the record. And so, for me, these cases raise quite interesting questions about the tension between women's victimization and agency. They also raise questions about how the victim's priorities might conflict with the state's priorities, and also about the relationship between state and community mechanisms for responding to rape. Many of these tensions also manifest in the second category of rape cases I want to walk you through quite quickly. So these are promise to marry cases, and they usually involve allegations that the victim was deceived into having sex with the defendant based on a fraudulent promise of marriage. And so the prosecutor's argument in these cases is that the fraud or the deception practiced by the defendant, it negates or it cancels out the victim's sexual consent, and that these cases should therefore be understood as a type of non-consensual sex or rape. They are quite a significant proportion of the cases in Delhi's trial court. So of the 254 judgments that I looked at, 84 were promise to marry cases. And in 55 of these, the acquittal stemmed from the fact that the victim refused to support a prosecution. And of course, all of the various factors and influences that we've been talking about already, I mean, they continue to be in operation for these cases as well. But something quite curious for me was in almost 40% of the promise to marry cases in my data set, the victim and defendant were already married to each other by the time the judgment was delivered. And the fact that the defendant was probably agreeing to marry the victim in order to avoid a rape conviction was not something that the victim tended to agree as a matter of the formal record. But outside of the formal record, it was a bit of an open secret that the primary motivation in filing the rape complaint was always marriage rather than a conviction. So you see this reflected, for example, in the words of this victim support person, who says that the victim is very rigid. No, he is the only one I want to marry. in all these cases, the only objective of the girl is to marry the boy. And so again, for me, this is interesting because it shows that what the criminal justice system is offering, i.e. a conviction, is not necessarily what the victim is looking for, which is a marriage. And I'd say a bit more about the desire for marriage underpinning these cases, but I just want to say a little bit more about the profile of these cases to give us a fuller sense, right, of what is at stake. And the first thing to note is that the sexual relationship in these cases usually develops in the context of a really prolonged romantic attachment. And I mean, this is what makes the promise of marriage believable in the first case, in the first place. But that intimate relationship itself is quite often characterized by a heavy amount of economic, psychological, emotional, physical, and sexual abuse. So, for example, one promise to marry victim I interviewed, she talked about how she was a committed Catholic. On her account, she had been quite clear from the outset that she was only interested in having sex with someone who would ultimately be her husband. And when the intimate relationship developed, the defendant also took huge amounts of money from her. So on the pretext that he would use that money to then pay alimony to his ex-wife, and then he would become free to marry the victim. So there was quite a lot of economic exploitation. She relayed incidents of physical violence. She also mentioned being forced to undergo multiple abortions, and this was an especially fraught experience for her on account of her religious faith. In the end, though, she narrated that he refused to marry her because he said that she was too dark-skinned to be his wife. And none of the abuse that actually happens within the context of these intimate relationships will reach the police or the criminal justice system, right? If anything, there is a heightened anxiety on the victim's part that reporting the abuse will remove the prospect of then having this relationship validated through the respectability of the institution of marriage. And it is only when the promise of marriage turns out to be fraudulent that she will turn to the criminal justice system. And when that marriage once again becomes a realistic possibility, the conviction stops being a priority. And this can then result in a situation where the victim's testimony doesn't support the prosecution. So why is the complainant seeking reconciliation rather than retribution? Again, I think the domestic violence literature is quite helpful here. So it talks about intrapersonal, relational, and also social reasons for why women in abusive relationships might want reconciliation. The interpersonal reasons can be quite varied. But relationally, of course, these are cases in which the victim does have a strong romantic attachment to the defendant, and so she might want reconciliation for that reason. But I think the social reasons are also quite important here. I mean, we've spent quite a lot of time talking about the various historical and contemporary reasons for why marriage continues to be quite a central institution in India. And so it's quite likely that these victims are already facing family as well as social ostracism for entering into an intimate relationship outside the context of a marriage. And this can be particularly pronounced if the defendant is also from a different caste or religious background. So this social isolation can then heighten the victim's vulnerability, and she might feel like she has to prove at all costs that the relationship is in fact a success, because she's already made too many sacrifices to be with the defendant. And given that women are themselves developing their preferences in a context that prioritizes marriage over sexual autonomy, it can be quite tricky to separate out at which point, context stops being relevant and agency takes over. So I find this quote from this lawyer interesting. I mean, she starts by saying that this association between sex and marriage is a result of women's illiteracy. But then she also extends this association to herself, right? Even though she's a fully qualified lawyer, highly educated. And then she also extends this assumption to me And I also met her as a qualified lawyer with sort of multiple postgraduate degrees in law. So it really seems to be about something more than illiteracy that she has in mind here. So she says for Indian women, sex is a very big thing for them. Still now, it's a big thing for me as well. I'm sure for you also. I'm sure nobody can just go and sleep with someone. I need to have sex to satisfy myself. Sex is something synonymous with marriage. And so I think there is something reflected in this quote about how marriage remains the ticket to respectability. And this then, to a large extent, dictates whether women are able to imagine sex outside the bounds of a marriage. And for me, this point is also exemplified in this very evocative way in Sneha Krishnan's study of young women in a different part of the country, which is trying to understand their sexual self-expression. And so her participants distinguish between rape and violent rape. And just assume when I'm talking about the Krishnan study that I'm using the term rape within scare quotes, right? So for her participants, the unqualified word rape referred to their experience of men's passionate behavior or uncontrollable desire. So Krishnan records her participants saying, "Did your boyfriend rape you or what?" Or "I just want to go out and get raped, dude," while discussing their dating life. And one 18-year-old young woman takes great delight in describing her rape by her boyfriend as the kind of sex that leaves hickeys. And so, since there exists no socially acceptable vocabulary for discussing these women's sexual desires, the word rape comes to stand in for all types of illegitimate sex, including any sex outside of marriage. And the denial of sexual agency then becomes one way for these young women to maintain their respectability. It is, however, really frustrating for many practitioners that victims in these cases continue to link sex with marriage. So a feminist academic I spoke to, for example, was really rather disappointed that these women take that initial step of challenging the idea that sex has to be within marriage, but then ultimately seem to want to fall back into the safety net of marriage. Other practitioners were a bit more strongly worded in their condemnation. So this is, again, quite an experienced criminal lawyer. So who's referring to the rituals associated with a Hindu wedding in this quote, where he says, somehow in some part of the mindset of people, you still have that concept that I'm supposed to offer my body to anybody only after I've had vermilion put on my head or a garland around my lousy neck. And then you also see a third category of frustrations around these cases, which was not so much the frustration that rape laws were invoked in these cases, but the fact that the victim didn't stick with her story to the end. Right? So this is a victim support person who says, what I mean to say is the victim should be stable in her statement. Don't get diverted. Simply say, I want him to be punished because he has raped me. He was in a relationship with me for 3 years, and after having sex with me, he refused to marry me. So taken together, I think both these categories of rape cases, they raise quite sticky questions about victimization and agency. They're examples of how women in India leverage rape laws to secure outcomes which might be incompatible with stated legislative objectives, but which are better aligned with women's own conceptions of justice. And these conceptions of justice, again, are in turn quite tied to women's material and social conditions. So they involve selecting the least bad option from quite a limited menu, making it difficult to draw neat boundaries between victimization and agency. So I don't claim that victims never want retribution. And I also don't think that necessarily what victims want needs to be determinative of what the legal system offers them. But if some of the agreements that I've talked about today make us uncomfortable, then to me, that's a strong indication that we need to look at the social and institutional factors that are impelling victims to enter into those agreements. So if we are uncomfortable about a victim trading a rape conviction for money or for employment or for housing, then that's a pretty strong sign that we need to focus on women's unemployment or poverty or homelessness. If we don't want women to pick custodial or alimony rights over the rape conviction, then that again is a strong sign that we need to provide women with safe and accessible routes to be able to exit unhappy and or abusive marriages. If we don't want women to invoke rape laws in sort of promise to marry cases, then again, we need to work towards a society where women can explore their sexual desires more freely. So what's so just about criminal justice? As it stands, it doesn't seem like there's very much, but I think taking women's legal world seriously can maybe help us work towards something better tomorrow. So I'm going to stop with that, and I'd love to learn what you thought of my idea.
Thank you very much.